Funding for this program is provided by the National Institute of Justice.
Residential punishment, 19 years, Texas Department of Corrections.
Hello, I'm James Wilson. A 20-year-old man walks into a convenience store, pulls out a gun, and holds up the clerk. He takes some money and leaves. No one is hurt. He is caught, prosecuted, and convicted. The judge discovers that the young man has previously been convicted of a burglary and a robbery. If you were that judge, what sentence would you impose? In Massachusetts, the law allows you to give that robber any sentence you like, from probation up to imprisonment for life. But if you're a judge in Minnesota, the law requires you to impose a sentence determined by this chart, the Minnesota Sentencing Guidelines Grid. Down the rows of the grid are the different kinds of crimes committed. The man convicted of holding up a convenience store was guilty of a level 7 crime, aggravated robbery. Across the columns of the grid are the offender's prior criminal record. This robber had a record equal to 3. The box where the row and column intersect determines the sentence, 49 months in prison. The judge is given some leeway. He can impose a sentence as short as 45 months or one as long as 53 months. Massachusetts is a state with an indeterminate sentencing law. Minnesota is one with a determinate sentencing law. At one time, almost all states used indeterminate sentencing. The idea behind it was to allow the judge to match the sentence to the individual traits of the offender, in hopes that these tailor-made sentences would help rehabilitate the criminal. In such states as Massachusetts, the actual time a person served in prison was determined not by the judge, but by a parole board. But growing disillusionment about society's ability to rehabilitate offenders, coupled with worries about the injustice of giving similar offenders very different sentences, led many states to adopt some kind of determinate sentencing law, mandating definite prison sentences and eliminating the authority of a parole board to decide how long a person stays in prison. By 1983, 9 states had abolished the power of a parole board to let out offenders early and adopted some kind of determinate sentencing law. In 1984, Congress passed a law that will require that federal judges follow more precise sentencing guidelines and will phase out the early release function of the parole board. Some people feel that forcing judges to use the Minnesota sentencing grid is wrong. It's like turning over sentencing to an impersonal computer that neglects important but subtle differences among crimes and criminals. Others argue that having these guidelines makes sentences more fair and more certain. Joining me in our studio are Kay Knapp, Executive Director of the Minnesota Sentencing Guidelines Commission, Judge Robert Hallisey, a Justice of the Superior Court of Massachusetts, and Brian Forst, Director of Research of INSLAW, an organization that has done a major study of sentencing disparities. Mr. Forst, you have studied how judges in fact make up their sentences. How much disparity is there among judges in determining how long a person goes to prison?
Well, Jim, actually there's a substantial amount in the research that we've done and research that's been reported in scores, if not hundreds, of studies that have been published both before and after our work. The evidence has been quite unmistakable of the existence of sentencing disparity, and it has resulted both from studies that have looked at actual sentencing decisions and studies that have given case history information for the same case to a group of judges, asking them what sentence they should give. In both kinds of studies, both in our work and in work that's been done before and after our work, the finding has been substantial disparity. Let me give you 2 examples. In Washington, D.C. in 1974, there were 28 judges who gave sentences each of whom gave sentences in at least 20 felony cases. 13 of the judges incarcerated 69% of all of the convicted offenders, whereas 15 of the other 15 judges incarcerated only 46% of the convicted offenders, despite the fact that the cases were randomly assigned to the judges. Clear evidence of disparity in Washington, D.C., where there at that time were no guidelines and are not now. At the federal level, we, rather than looking at actual sentences, looked at the experimental approach. We gave 16 case scenarios to over 200 federal judges and asked them what sentences they should give. In 9 of the 16 cases, we could find one judge who recommended probation and another judge who recommended at least 20 years of a sentence.
Well, let me ask you this. Disparity, I think, to most of us means that the sentence cannot be explained by the nature of the crime or the past record of the criminal or other obvious legally relevant circumstances about the crime. What else is involved here? Let me put the matter even more bluntly. Is it the race or sex or class of the defendant that affects the way the judges sentence it, or is it something else?
Well, there are a number of factors that matter. Probably the most important factor is the judge's personal view about what the purpose of sentencing is and how he happens to feel about the particular offense at issue. Judges who support the rehabilitative goal of sentencing tend to give more lenient sentences by about 10 to 20% on average than judges who support the goals of deterrence and protection of the community as primary purposes of the sentence.
Is there much research that indicates how the defendants feel about this? We say that, or some people say that this system might be unfair, but is it perceived to be unfair? Do the defendants simply take what they get and not complain?
Well, the defendants apparently, based on the evidence that I've seen, do indeed see unfairness. In fact, it has been alleged that the Attica riots in the early 1970s were a direct result of a perception among the inmates of sentencing disparity.
Ms. Knapp, you've been the executive director of a commission that has developed this remarkable grid that we saw on the graphic a moment ago. How did you and your commission go about deciding how many months this person who was convicted of aggravated robbery should get? Why 49 months rather than 67 or 32?
Like any policy development process, there were many things that were looked at to come up with the final grid. The commission had to determine not only the length of imprisonment for those that went to prison, but the commission also had to determine how many people and what kinds of people should go to prison in the first place rather than be on probation with perhaps some local jail time. And so there were a lot of decisions that had to be made. We, as every other state, has limited correctional resources in which to house offenders that we want to incarcerate, and that became certainly a constraint on what the commission could do in terms of developing sentences, and therefore it became just a question of choices of whether to send more people to prison for shorter periods of times or to send fewer people to prison for longer periods of time. The 49 months was the outcome of that long, detailed choice process, and it was merely a policy decision.
Now, what has been the effect of having these guidelines? Do the judges actually conform to them by and large? If I committed that convenience store holdup, could I expect to get 49 months given my criminal record?
Yes, you could expect to get it. One thing you did not mention in describing the grid is judges can depart even beyond the range that is provided if there are substantial and compelling circumstances involved in the case that would justify a longer or shorter sentences, and then that sentence can be appealed to the Supreme Court. And
can it be appealed by either the prosecution or the defense?
By either, that's correct. But by and large, the judges do follow the presumptive sentences because there are not that many cases with substantial and compelling circumstances. In terms of whether or not a person goes to prison according to the guidelines, the judges follow that decision, the presumptive sentence, in 91 to 94% of the cases, and for the durational decision for those who do go to prison, the judges follow the sentencing guidelines about 80% of the time.
And if they don't, what happens?
The judge will provide reasons for going outside of the guidelines, and if the case is not appealed, the sentence will stand. If the case is appealed, the appellate courts will decide whether it was an appropriate departure or not.
Are there many appeals?
There have been about 200 opinions so far, and we've had about 24,000 cases. So a small proportion of the cases are appealed, but the case law is important in developing what the appropriate sentence is.
Was there any thought in developing these guidelines that beyond reducing disparities, they might have some advantage in making criminal sentences more certain or more swifter, or was the crime control implications of this guideline really a subordinate matter to the issue of disparity?
One of the goals was to make sentences more certain and to have truth in sentencing so that the public would understand what the appropriate sentences were for each kind of offense. And that certainly was a goal of the guidelines. Crime control as a goal was not incorporated specifically into the guidelines. I think the Commission felt that the particular sentencing structure you develop and implement is not going to affect crime rates significantly one way or another, and therefore what they attempted to do was to come up with a more manageable and more accountable, fair, and more certain sentencing
What has
system.
happened to prison population as a consequence of the new sentencing guidelines?
Prison populations initially went down slightly, which is what we had intended because our prison populations were getting to be at capacity and we felt that they should be not quite that high. So they did decrease for a short period of time, and then they started to increase as they were increasing in the rest of the country for about a year or two. There were legislative and commission interventions that stopped that increase.
By what, reducing the length of the sentences to keep the prison capacity constant?
There were some reductions in some of the durations, not too many, but there were also some other legislative changes, basically reductions in mandatory minimum sentences that control the prison population.
Judge Hallisey, you come from a state which throughout much of its history has had an indeterminate sentencing law. You heard the facts of this case in very abbreviated form, and obviously you'd like to know a lot more before you made up your mind, but from what you have heard, what kind of sentence would you have given this convenience store robber?
Well, when I first thought about it, I would think about probably 8 to 10 years at Walpole, our maximum security prison. He wouldn't serve the 8 to 10 years.
About how long would he serve, do you suppose?
Generally speaking, he'd be out in 2/3, which would be 5 and something.
5 years or so. So your sentence would mean about 60 months or so inside prison, and your sentence would mean about 49 months or so inside prison.
Actually, it would be less than that because our offenders can earn good time at a rate of about 1/3 of the sentence. So the likelihood is that the term in prison would be shorter than 49
So your
months.
sentence might in fact be only half as long in Minnesota in terms of time served than the sentence in Massachusetts. How do you feel about constraining your authority by the use of sentencing guidelines or presumptive sentencing laws? Would you be in favor of it, or would you be opposed to it?
What I say about sentencing, Jim, is I can use all the help I can get from any source whatsoever, because it is one of the most difficult things that a judge has to do, probably the most difficult thing.
What about the Minnesota sentencing guidelines? Would you like to see that grid put down on your desk and you say, you sentence 49 months?
I would not be happy with that. I don't claim to understand it fully. I've only studied it cursorily, but I see that it starts out, first of all, saying that the only thing we're going to be concerned with is retribution or punishment. Now, to me, that's only a very small part of the story. In my view, the crime is one thing, but the criminal is the other thing, and that a judge should evaluate them both in all of their complexities.
When you evaluate the criminal, what do you take into account? What are you looking for?
Oh, I'm looking for anything that throws a light on what he did, why he did it, and most particularly what sort of a fellow he's going to be in the future, if he's in jail or not in jail. Motivation, now you take your hypothetical. We don't know what color this fellow was. If he spent his whole life in the ghetto, a high crime area, and at 20 all he has is these 2 prior criminal records, that isn't all that bad. On the other hand, if he's in an affluent suburb, he's a very bad fellow.
So you'd be inclined to sentence the more affluent offender more severely owing to the differences in background?
I would think that it's more likely that he's a bad apple. I think that would count against him if he came from an affluent society. We don't know what his motivation was. If he's got 5 kids or a wife that needs money to get an operation for cancer, that I think would operate in his favor. If he's a drug addict, actually, I count that as in his favor. He's compelled by a drive that he can't control. On the other hand, if he needs money to chase around at the horse tracks or gamble, I think that would count against him. So I'd like to know lots more about this fellow.
But what do
before I
you
make a final
hope to
decision.
accomplish by knowing more? Do you hope to design a sentence that will rehabilitate the offender, or do you simply hope to design a sentence that is more just in the sense that it takes into account more circumstances pertaining to the
I think
individual?
what I try to do is evaluate the evilness, if I can use that general word, of what he did to start with, and then have to make, of course, a basic decision whether he's going to be locked up or not. And now everybody pretty much gets out of jail. We don't kill people anymore. We don't lock them up for life. We say life, but they're not away for life. So I try to figure what's going to be best downstream. Mm-hmm. Should we let the fellow outside? Can he be salvaged now? If we put him away, what kind of a creature is going to come out downstream?
Well, you use your discretion that the law gives you in a sensitive way. You try to understand more about the crime and the criminal and try to do what's best for all concerned. But doesn't a law that permits you to behave in that way permit another judge, perhaps in the very next courtroom, without your good intentions, to impose his own personal prejudices, to act hastily, to be vindictive, or to be excessively lenient? Isn't the indeterminate sentencing law a law that can only work in the hands of well-intentioned judges?
Well, you could say that, but of course half of those things you said would probably be a violation of the judge's oath, and I assume that they don't do that, Jim.
Yes, but well, of course, some people worry that judges are not sufficiently constrained by their oath. They're human beings. I grade my students in a course, and sometimes I have a feeling that I give them, some students, a C or an A depending on what I had for breakfast that morning. Now, other people have alleged that judges give out criminal sentences depending on what they had for breakfast that morning. Is that a matter that worries you?
Of course it does. It's a very complex problem, and I suspect that the same judge on different occasions may come out differently, and that may not be unreasonable. We, as you know, are a circuit court, and a particular crime may call for one punishment in Boston, quite a different punishment out in Pittsfield or in Northampton. To the extent that deterrence is a factor, and I think it is, you have to see how rampant that crime is in that community at the particular time, how much deterrence is required. Stealing bicycles is not a very big deal anymore, but in some communities it's a very serious crime.
Now, Brian, you've heard these arguments that Judge Hallacy has made before, because I'm sure the judges you've interviewed have said many of the same things. What is your reaction? Do you feel that taking more circumstances into account, including very subtle and hard-to-measure circumstances, is a reasonable way for judges to act, or do you think this opens the door to abuses and unfair disparities?
Well, I think that it does do the latter. We all, when faced with complex decisions, tend to have difficulty making a consistent decision. There are ways of making decisions more even-handed. The way that sentences are currently being made is not conducive to even-handed sentences. And I hasten to add that we are perhaps pinning too much of it on the judges, and I think it's appropriate to think not so much of sentences as criminal sanctions, and observe that the sanctions that offenders get are a function not only of the quirks that judges may impose in their sentencing decisions, but also those that a prosecutor brings in filing charges, in inducing pleas, and under the old parole board system, the whims that a parole board might have in determining when to release an inmate. So
well, the point you just made, if I could interrupt for a moment, brings to mind a question I wanted to ask Ms. Knapp. Kay, what about this problem of having guidelines that are based on just two factors? Is it the case that these two factors simply don't exhaust all of the legally relevant and appropriate considerations? And while you're thinking about that one, I'll tell you the next question I'm going to ask. If the judge's discretion is reduced, isn't it likely to be the case that the prosecutors will have their discretion expanded in deciding what to charge these people with in the first place? And therefore, we're right back to indeterminate sanctions, to use your word, because now it's the prosecutor using this authority.
Right. Two very good questions. The two dimensions don't exhaust either the legally or socially relevant factors in determining sentence. In fact, as I indicated, judges can depart from the presumptive sentence on the basis of some other factors. For example, if the offender has reduced culpability because of some sort of mental or physical kinds of deficiencies, that's a reason to mitigate sentence. If there was particular cruelty in the commission of offense to the victim, that's a reason to aggravate sentence. So there are various factors that can be brought in. In terms of the changing of discretion, certainly the system, the discretion in the system changed with the sentencing guidelines. But it was not just reducing judges' discretion. In fact, judges' discretion increased because prior to the sentencing guidelines, the parole board had a tremendous amount of discretion, and it was the parole board that determined the actual sentence, just as in Massachusetts. What our system did was take that power from the parole board and distribute it between the judges and prosecutors. The prosecutors do get more power because they determine the conviction offense and the charge, and that in turn is tied to the sentence. So there's no question that their discretion has increased, but so has the judges, because now the judge gives the real-time sentence. Prior to the guidelines, the parole board did.
I'd like to see you and Judge Hallisey sort of go eye to eye on the following question. He says that among the factors he would like to take into account in reaching a decision is where the person lives, whether he grew up in a ghetto, whether he has been involved in drugs, and all of the other factors you've heard him mention. Now, even under an expanded definition of the Minnesota sentencing guidelines, it's hard for me to imagine that judges would be authorized to take those factors into account. What would you say in response to his concern? Do you think that's wrong?
Well, in Minnesota we determined that would not be appropriate, especially the issue of drugs. We found that some judges would use the use of drugs as a mitigating factor. Others would use it to aggravate a sentence. It was not used at all consistently among offenders, and decided that it should not be used, especially to mitigate a sentence. In terms of where a person grew up, we also found that while some judges wanted to make sentences harsher for the more affluent offenders, by and large, the data on sentences suggested that the opposite were true, that it was the poorer defendant that by and large got the harsher sentence. So those sorts of factors were excluded from consideration.
What do you feel about this? Would you like to move to Minnesota because Ms. Knapp has persuaded you of the wisdom of it?
Far from it, Jim. Just because judges don't do the same thing all the time, it doesn't seem to me to permit people to put a disparity label on it, which to me is a judgmental word. To me it's a difference of opinion that may be in perfect good faith by people of different persuasions. And you go to two different doctors, one says you should have surgery, the other says you shouldn't, you should treat this conservatively. Now they're both within the range of competent doctors, they have a different opinion. I think more study should be done to see which of the views is more right than wrong, not just brush it aside altogether as a legitimate factor because judges differ on it.
Some people have made to me the following argument, that the right analogy is not between judges and doctors and how you treat an ill person, but between judges and tax collectors. And would we want a law that said your income taxes will be determined by the IRS on the basis of the commissioner's determination of your character, your place of residence, your nature, your dispositions, or would we prefer a tax schedule that says if you earn X dollars, you pay Y taxes? Which is the appropriate analogy? Is it the medical analogy or the tax collector?
I have trouble coping with that analogy. Of course, I think that the whole tax structure has always been government's way of encouraging or discouraging certain activities. And maybe it comes to the same thing. I don't know, but I've never thought of it in that analogy. So I pass on that.
Brian, one of the things that struck me about this conversation so far is how little attention has been given, and I think perhaps rightly, to a subject that most people think is at the heart of this. When you say judicial disparity or sentencing disparity to many people, they immediately assume that disparity equals racial prejudice, that is really what is going on in our courts. What is your sense of the scholarly evidence on the degree to which the race of the defendant is a significant influence on the sentence defendants get?
Well, Jim, most of the research that I've seen, which takes account of not only race, but a whole host of other factors, finds that it's quite rare for race to play an important role in the sentencing decision. That is, if one just looks at race, one might find that black people are more often incarcerated than white people, but after controlling for the severity of the crime and a whole host of other factors that enter into the sentencing decision, most studies find, with a few important exceptions, that race does not play any significant role in sentences that are given out in contemporary America.
Well, what has happened with respect to race in Minnesota? Have there been differences in how the frequency with which blacks have been incarcerated or how long they've been incarcerated before and after the sentencing grid?
Yes,
What
both
were the
before
changes?
and after. There's been very little change in that aspect of sentencing, and it's something that the Commission certainly is looking at and the legislature is made aware of. We've not found any improvement in that area. Overall, there has been improvement in, if you just look at general classes of offenders, that they get generally more uniform sentences now than before the guidelines, but we've not found the racial improvement we were hoping for.
Well, when you say racial improvement, that suggests you believe there was a racial problem. Do you disagree with Brian's suggestion that the evidence doesn't support the argument that race is a big factor in sentencing?
Race by itself was not a big factor by itself, but when you tie that with the economic variables, especially employment things, which is racially correlated, then it becomes, so it's not directly related, but the economic status of the offender was very important.
That employment is an interesting
Yes.
variable in sentencing.
Yes.
Should judges take it into account or
Yes.
not? I think most of us would say, well, they certainly shouldn't take into account race, and probably not sex,
Right.
but employment. In one sense, it means the person is a member of the community or not if he's employed. In another sense, it doesn't really have anything to do with the commission of the crime. What do you think employment is a legally relevant variable, morally relevant variable in sentencing persons?
I think it is, Jim. I think it shows, in some cases, a willingness to come by money in an honest way through one's labors, which
So
is
you'd be
a
inclined to
sign.
give persons who have a spotty employment record, despite the absence of employment opportunities, somewhat less consideration than somebody who has a good employment
I
record?
hope I didn't say that. If they're unemployed because there's no employment around, I don't think it should count against them. Tying it in with the race question, I know in my own case, I have not incarcerated some black fellows who otherwise would have been incarcerated because of the fact that they had a job. And I knew perfectly well that if I locked them up for as short a time as 3 months, they'd lose the job, and it may be years before they got another one.
Thank you very much for joining me. Thank you, ladies and gentlemen. For Crime File, I'm James Wilson.
Funding for this program was provided by the National Institute of Justice. This program was produced by the Police Foundation, which is solely responsible for its content.